Guten Tag, meine Damen und Herren, aus Colorado. Vielen Dank für Ihre Zeit heute. Ich heiße David Traylor und meine Firma ist Golden Eagle Partners. I am an investment banker, as he just noted, and I hope to make this engaging and a provocative conversation. So certainly I can keep you awake after lunch. So I am not a patent attorney, although I do have some relevant background that I think is pertinent to this conversation. I have 15 years of operational experience in biotechnology companies based in Boulder, Berlin, and Silicon Valley. I have 7+ years of experience in the cannabis sector, and also I'm the inventor on 3 US patents, 2 in bioprocessing and 1 that just issued 4 years ago in 2017. So this obviously is a very interesting and very tough topic to cover in 30 minutes, but I hope to provide some provocative thoughts and ideas to that. The other thing before I jump in to note, further the reading, there's a recently published article in the Journal of Cannabis Research, Trends in Intellectual Property Rights by Wise and Luria. So you might look that up. I think it's freely available on the internet and has some very interesting data on patents and patent grants, et cetera, in cannabis. The other thing I wanted to mention with regards to the science, I'm chairman of the Scientific Advisory Council for Athletes for Care. You may have heard of Athletes for Care. It's an athlete group in the US based on espousing the benefits of cannabis. And I am the chairman of their Scientific Advisory Council, and we've put together some leading scientists from around the world, Spain, Uruguay, Israel, US. We're building that out. So just wanted to also put that out there. So before I jump in, I wanted, first of all, talk about some definitions. The definition of cannabis, when we're talking cannabis today, we're going to talk about marijuana, hemp, really any plant or molecule that really stems from a cannabis genus, phytosource or synthetic source, whether it's a terpene or a cannabinoid or a similar molecule. Also, for simplicity's sake, we'd like to just limit the discussion to patents and not necessarily tackle the issues stemming from trademarks, copyrights, and trade secrets. But during my discussion today, I'd like to first talk a little bit about where we're seeing things in the cannabis sector with regards to the historical perspective. Compare that to what we saw the early days in intellectual property for biotechnology, and then hopefully end with maybe some conclusions on where we might see things going here the next few years in cannabis intellectual property, and again, mainly pertaining to patents. Before I jump into a couple of terms that I think most of you know, utility, does the invention have value or economic value? Novel, is it a new idea or concept? Novelty is certainly an important part of being able to get a patent. Enablement, the patent needs to provide direction so somebody well-versed in the art for the invention can really reproduce that invention. And then also non-obviousness, which is kind of a unique patent term, which we will talk about here shortly. And essentially, again, it's meant to be a concept that's non-obvious to somebody that's typically practicing the art for that invention. So for the current state of cannabis IP, one thing I think that's interesting about cannabis, if you look at the patents that have been issued and some of the patent applications and the what's being pursued for patent protection is pretty heterogeneous, pretty varied across the spectrum. And I think that comes from the supply chain of cannabis is pretty different. So as I mentioned, the Wise Luria paper is an interesting paper, and it mentions that really you have upstream technologies, which are talking about cultivars and genetics and seeds and pest control, cultivation methods and equipment. And then you have midstream technologies, which are more about separation, extraction, purification, chromatography, right? And then you have downstream technologies, which are talking about formulations, compositions, methods of use, indications. So a lot of variation between all those subject matters. The way we look at cannabis is the modern cannabis age started in January 1st, 2014. Obviously, I'm biased being here in Colorado. California did legalize medical use in the late 1990s, but we believe January 1st, when the first sales of adult use in Colorado kicked off, was really kind of when things got going. Now, if you're talking about intellectual property, it's interesting because GW Pharma, as you know, was founded in 1998. And obviously they were filing for patent coverage on the EPO and the USPTO well before then. But our perspective, my perspective, is that GW Pharma is more of a biotech company than it is a cannabis company. But certainly people have their different perspectives. So if you really look at that, it's really been 7 years since things really got going. The first few years were really mainly centered on brands and how to establish brands and less on intellectual property. But as many of you know, sitting in Frankfurt, that's changing quickly. And part of that has been stemming from the deal that was announced in February, right, with Jazz Pharmaceuticals acquiring GW Pharmaceuticals. And from our perspective, that deal mainly was predicated or based on the intellectual property that GW Pharma has. I think last count, I think they have 78 issued patents, something on that order. So obviously they are one of the leaders, if not the leader, in intellectual property in this space. The one thing I think that hopefully you will see in this discussion is there are some important cases that will determine really the course of this industry and for many companies. And I think that's one thing you will find when I do the comparison to biotechnology and biotechnology companies. Okay. So there are 3 relevant cases that we thought would be interesting to talk about today. First of all, the first one is Incise and their suit against GW Pharmaceuticals. That court action was started in 2016. You have the United Cannabis Corporation patent infringement lawsuit, which was filed in Colorado against Pure Hemp Collective, and that started in 2018. And then most recently, you have the big case of Canopy Growth, the Canadian LP, suing GW Pharmaceuticals, and that just happened in December of last year in 2020. So as I mentioned, there's a number of concepts common to patents, and one of those non-obviousness was really the main center point for the incest suit against GW Pharmaceuticals. Again, that suit action was filed in December of 2016, and that stemmed around patent 9066920 or patent 920. That patent was granted in mid-2015. And really the main part of that patent was talking about treating epilepsy with phytocannabinoids or a combination thereof, okay? And the whole idea on this court action was that Incise thought that, excuse me, all the claims that defined the 920 patent were obvious. And as a result, if they were obvious, they were not patentable and thus not valid, or should be struck down as invalid, right? So over those 3 years or 2.5, decision came out in January 2019. And since it was a US patent, the ruling came from the USPTO, Patent Trial and Appeal Board, or known as PTAB. And essentially, the ruling came down really in two parts that I think were interesting. The first ruling, PTAB found that claims 1 and 2 in the 920 patent were obvious, and as a result, were not valid. But then the other part of the decision, they had claims 3 through 13 that were ruled to be still valid because Incise failed to meet its burden to show that those claims were invalidated due to obviousness. And so those 3 to 13 claims remain valid. And as a result, the 920 patent still has teeth and is still largely enforceable, although it doesn't have claims 1 and 2, which I think is interesting too, because these are 3 of the main cases. And right now, as of today, the remaining 2 cases remain unresolved. So the second case we wanted to talk about was the case from United Cannabis Corporation and filing against Pure Hemp Collective. And this suit was brought in 2018. And this essentially July of 2018. And again, they filed this in the district court in Colorado around patent 9730911, or the 911 patent. And that patent's title was Cannabis Extracts and Methods of Preparing and Using the Same. And that patent was granted in mid-2017, August 2017. And the idea was that United Cannabis believed that products being sold by Pure Hemp were infringing on its patents, or on its patent on the 911 patent. And during this course of this court action, Pure Hemp counterclaimed that United Cannabis claims were unpatentable, kind of stemming from the same as the previous case, patentability, novelty. Pure Hemp maintained that since CBD products were ubiquitous at the time in the marketplace, that the claims in the 911 patent were not valid. Well, so there's a couple decisions that have come out of this case. First of all, in April of 2019, the court found that Pure Hemp failed to show that the liquefied version of its cannabinoids-related concepts specified in 911 is a natural phenomenon. So that's the one thing I think that's going to be interesting in cannabis patents, is you have a patent around concentration levels of a certain preparation that are much higher in concentration than naturally occurring in cannabis sativa, for example. And that was the main finding by the court in the counterclaims, that they thought that the Pure Hemp counterclaims were really not valid in their nature because of the concentration level of the molecules in the patent versus preparations and naturally occurring concentration of those molecules. And it turns out too, due to United Cannabis fiscal problems, they tried to file bankruptcy. And just to make cannabis more interesting in the US and worldwide, United Cannabis tried to file bankruptcy, but they couldn't because it's nationally illegal, and bankruptcy is a national procedure here in the US. So that was not allowed. And essentially, earlier this year in April, that it was ruled that this is going to be put on hold due to the fiscal woes of United Cannabis. So essentially, the validity or unvalidity or non-validity of the 911 patent still remains unresolved. Okay. Perhaps the most interesting of all these, and we'll see, have to see where this goes, because again, this is pretty new, and the final decision will be coming in December 2020. Canopy Growth sued GW Pharmaceuticals in the U.S. Western District Court of Texas, stemming from patent 10.87632. And this is essentially a broad patent for the process of producing an extract containing tetrahydrocannabinol cannabidiol from cannabis plant material and cannabis extract. So very broad. Essentially, the main stemming of this patent and its coverage is using carbon dioxide extraction processes to make a similar preparation for Epidiolex, which is the product that GW Pharma is selling and doing quite well with, right? And so what happened is Canopy Growth has rights to patent 632, and that issued on December 22nd last year, and pretty much simultaneously when that patent was issued, then Canopy Growth brought the suit to GW Pharma. So this process is still in, this court action still in process. It'll be interesting to see, goes back and forth where it leads, because the breadth of this and the relationship to how many companies use carbon dioxide extraction to produce products is pretty substantial. And I think you will find when we get here shortly to talk about biotechnology, similar suits, that this may become one of the more seminal suits, because some of the bigger biotechnology court cases that resulted in significant standards for patents in the US and abroad came between large companies like Canopy Growth and GW Pharma. So I'd like to move on to talking about a biotech comparison, patent law, and why maybe this, using biotechnology to look at where cannabis IP may be going and why that's relevant. First of all, when you look at biotechnology in the 70s, 80s, it was a new industry, similar to where cannabis is now and over the last 5 or 10 years. If you also look at both sectors, at the time when the patents really started to be filed, there was very little prior art to each of these sectors. And one thing I think that's very interesting between both these is you do have an issue of patentability, essentially novelty versus nature. And for example, you'll see here in a minute, one of the first cases I mentioned talks about, whether you can patent a naturally occurring molecule or something that's slightly modified by man. And I think personally that's going to be a precedent and something that's going to be pushed on here in the coming years with cannabinoids and really what's a natural cannabinoid versus maybe a man-modified cannabinoid. And then more importantly, with regards to cannabinoids, is the question on utility. And what is, can you patent something if you really don't know what a cannabinoid can do or do therapeutically? For example, a comparison was express sequence tags, which were small snippets of DNA sequence that Craig Ventnor was trying to patent at NIH back in the 90s. And there's a huge, big issue about it, mainly stemming from the fact of, can you patent a sequence of DNA before you really know what its utility is? And I think utility is going to become a big part of cannabis intellectual property arguments and litigation here in the coming years. One other thing I think that was interesting about when you look at biotech versus cannabis is you tend to, apparently it seems like you can have some conflict in intellectual property when you have a new technology being applied to an old sector. For example, new technologies like recombinant DNA technology being applied to human healthcare, which was an old sector. Or you have established technologies like supercritical extraction being applied to a new area like cannabis. And so maybe both those combined, I think, is also an interesting thing to think about as far as IP conflict goes. Another thing I think that's an interesting comparison between the two is I think early on in biotechnology, there was a concern that the examiners that were really doing a lot of the patent processing actually understood the industry, understood the technologies, and really could make astute decisions that related to the validity of claims in a patent application. And I think you could say the same thing for cannabis these days, and maybe it's less of a technical issue and more of an understanding of the industry and what you have naturally occurring versus man-made, right? But I think if you look back on the history of biotechnology, patents, and IP, there certainly was quite a bit of conflict that took place, and I think you'll hopefully see that here in a few examples. In 1972, Anand Chakrabarty developed a process capable of degrading different hydrocarbon components. And so the big question was, can you patent nature? And so this bacterium was supposed to break down oil in a much more rapid pace. And the USPTO came out and essentially rejected the claims because they said you cannot patent an organism. But then the Supreme Court in 1980 struck down that decision by a 5-4 majority, indicating that you can patent anything under the sun that is made by man, which is a very important concept, right? The next case we want to talk about was the insulin case using between the University of California, San Francisco, and Eli Lilly. And there was essentially 6 lawsuits. This is the first big recombinant product to be made via that technology. And so there are 6 lawsuits between the University of California, San Francisco, Genentech, and Lilly. And essentially what came out of the whole claims is that UCSF had claims to rat insulin, and essentially Lilly had claims to the human insulin. And in the end, Lilly ended up winning. And as a result, UCS claims to human insulin were not upheld. And so really Lilly and Genentech made off with all the royalties, and Lilly did not have to back pay any royalties. So again, a big fight. The interesting thing is that started in 1977, and that was not fully resolved until 20 years later in 1997. Finally, the economic power of patents was shown with, again, a big molecule, erythropoietin, or EPO. And that fight was between Amgen and Genetics Institute. And essentially, 87 Genetics Institute received a patent on EPO and a process to make it. And only a few months later, Amgen received a patent claiming the genetic sequence for erythropoietin and a recombinant DNA process to make it. And the initial ruling was that they both mutually infringed on each patent, which is crazy. And so the assumption was the court was finally going to rule that they're going to need to cross-license each patent to be able to practice their art. And what ended up happening is the Court of Appeals for the Federal Circuit in Washington instead upheld Amgen's patents and invalidated those from Genetics Institute. So essentially, Amgen gained exclusive rights in the US, and Genetics Institute had to pay $14 million in damages. And now it turns out Amgen, is still one of the main biotech companies in the US or the world. Genetics Institute is nowhere to be found. So one last, just 3 points to final close out with. We expect that the boundary between nature and novelty will be pushed in cannabis as it was in biotech, Diamond versus Chakrabarty. There will be landmark patent litigation decisions, which will be very important for parties involved. The winners will be big winners and the losers will disappear. And then there are also going to be patents that infringe on each other and provide significant issues, and frankly will be hard to rule on, like the Lilly and the UCSF, where you essentially have a lot of convoluted 6 suits and resolving it all together. So I think that if we look at biotech and some of the main cases, and maybe even go back to some of these and use these in cannabis, I think it's probably going to make the path in intellectual property and cannabis more clear in the near and long term. Thank you.